Hello, lawyers and learners. Today we are going to discuss one important topic of Hindu law, that is sources of Hindu law. Now, when we say sources of Hindu law, we are basically asking one simple question. From where does Hindu law come? From where Hindu law derives its identity? The answer is that Hindu law has developed from different sources over a long period of time. And broadly, these sources can be divided under two heads. The first, ancient sources, and second, the modern sources. Under ancient sources, we have Shrutis, Smritis, commentaries, and digests. And under modern law, we have legislation, judicial precedents, justice, equity, and good conscience. Now, let us understand these sources one by one. First, let us start with Shrutis. The word Shruti means what is heard. Shrutis are considered the oldest and most sacred source of Hindu law. They are believed to be the knowledge heard by the ancient sages. Under Shruti, we mainly refer to the four Vedas, that is Rig Veda, Yajur Veda, Samved, and Atharva Ved. Rig Veda introduces some of the earliest ideas about Dharma or righteous duty and also points towards the higher goal of spiritual liberation known as moksha. But these ideas do not exist in isolation. As we move through the Vedas, we can see how much one builds upon the other and complements the other, in fact, gradually creating a more complete picture of human life and its purpose. This connection becomes especially clear in the concept of the four purusharths or the four goals of life. While the foundation of righteous living are reflected in Rig Veda, later Vedic thoughts, particularly the Atharva Veda, is often associated with a more developed understanding of these life goals. Together, the Shrutis present a balanced and a duty-bound society guided by Dharma, that is righteous duty, Arth, that is wealth, Kama, that is pleasure, and Moksha, that is spiritual liberation. Along with the Vedas, the Upanishads are also very important. Now we must understand one thing clearly. Shrutis do not provide particular provision in a way a modern legislation does. For example, the Bharatiya Nyaya Sahita or the BNS clearly defines offenses and prescribes punishment for them. Shrutis do not lay down such rigid and specific rules. Instead, they create a philosophical and moral foundation of Hindu thought and Hindu law. That is why Shrutis are regarded as uncodified Hindu law. In simple words, they are not prescriptive laws और a plug and play legal code. ऐसा नहीं है कि आपने ये अपराध किया तो आपको ये सजा मिलेगी. Shrutis do not function in that manner. Rather, they provide a guiding principle, values, and duties which influence legal and social conduct. Therefore, as a source of law, Shrutis are regarded as uncodified source of Hindu law. But they provide the basic foundation, the basic spirit, and the ethical and moral duties which influence Hindu way of life. So Shruti is important because it gives philosophical and moral foundation to the Hindu law. Now let us come to the second source, that is Smritis. The word Smriti means what is remembered. Smritis were written by sages. जो हमारे ऋषि मुनीस थे उन्होंने ये लिखा था. They contain rules relating to duties, conduct, family life, marriage, inheritance, punishment, and social order. Smritis are generally divided into two broad main heads, Dharma Sutras and Dharma Shastras. Dharma Sutras are written in short prose form. Example includes Dharma Sutra of Gautama, Buddhayana, Apastamba, and Vashishta. Dharma Shastras are mostly in verse form. They acted as legal and moral guides for Hindu societies. Some of the most important Dharma Shastra are Manu Smriti and Yajnavalkya Smriti. Written Smritis dealt with several aspects of law, religion, and social life. Some cover a wide range of subjects, while others focus only on a particular area. Among these, some important are Yajnavalkya Smriti is especially important because it presents its subject matter in a very systematic way. It divides the entire discussion into three parts. The first part is Achara, which deals with the rules, conduct, and religious duties. The second part is Vyavahara, which deals with civil law and judicial procedure. And finally, the third part is Prayaschita, which deals with penance and expiation. Other important Smritis include Narada Smriti, Brihaspati Smriti. Both are particularly known for their emphasis on Vyavahara, that is legal rules, judicial procedure, and the administration of justice, rather than focusing exclusively on religious duties or penance. Manu Smriti is very well known ancient text, whereas Yajnavalkya Smriti is very important because It was considered somewhat more progressive than Manu Smriti and followed a systematic legal approach. Narada Smriti was another progressive Smriti of its time. For example, it allowed women to remarry under 5 situations of crisis. Example, for when her husband was missing and could not be traced, when he was dead, when he had become an ascetic and renounced worldly life, when he was impotent, and when he had been outcasted by the society. So we look at both together. Shrutis and Smritis complement each other. Shrutis lays the foundational principles and moral principles, while Smritis translate these principles into practical rules governing individual conduct, family relationships, and societal life. Having understood these foundational principles, let us now move to the third source of Hindu law, that is commentaries and digests. Over time, many Smritis were available, but sometimes the rule set out in one Smriti was different from set out in another Smriti, and there were contradiction among these Smritis. Two examples I'll quote of contradiction between Smritis here. The question, when can a son inherit father's property? To which some scholars believe that it can be done during father's lifetime. On the other hand, others laid that father's property can only be inherited by sons upon the death of the father. Accordingly, two schools of law developed, which we will keep for later discussion. Another contradiction was related to divorce. When can a woman remarry? In traditional Hinduism, there was no concept of divorce as such, and a marriage was considered as a sacrament. It still today is considered as sacrament. Some Smritis took a very restrictive view, while others took a very liberal view. For example, according to Manu, a woman is entitled to remarry if she is virgin, meaning the marriage is not consummated and her husband dies or abandons her. An abandoned wife can marry, but the waiting period is different depending upon her husband's reason for abandonment, according to Manu. For example, if a husband has left for some sacred duties, then she waits for 8 years. If he has left for or abandoned her for learning, she waits for 6 years. And if he has abandoned her for pleasure, she waits for 3 years. After these period elapse, she can remarry without incurring sins. This is different from the 5 reasons prescribed in Narada Smriti, which we discussed earlier. So naturally, disputes and confusions arose in society due to different ideas in various Smritis. To reconcile such discrepancy among Smritis, commentaries and digests played a key role. To solve this problem, medieval scholars wrote detailed explanation and collection of rules. These explanations are called as commentaries. In Sanskrit, commentaries are called bhashya, and the collection or summaries of rules from different smritis in form of essay is called digest. In Sanskrit, digests are called as nibandh. These commentaries and digests help in interpreting smritis, and this process gave rise to two very important schools of Hindu law, namely Mitakshara school and Dayabhaga school. Mitakshara is a commentary on Yajnavalkya Smriti written by Vijnaneshwara. It became influential in most parts of India. Dayabhaga was written, on the other hand, by Jimuti Vahana and became influential mainly in Bengal, Assam, and what is today some parts of Tripura and Orissa. These two schools are very important, especially in matters of joint family, property, co-partnery, and inheritance. But we will not go into details here. We will study Mitakshara and Dayabhaga and also compare both of them in a separate video. Now let us come to the fourth source, that is custom and usages. Custom means a long-standing practice followed by a particular community, family, caste, tribe, or locality. The Sanskrit word for custom is sadachar, meaning a conduct that has been followed always since time immemorial. In simple words, if a particular practice is followed continuously for a long time and the society accept it as binding, then it may get the force of law. For example, a family or community may have a special practice relating to marriage, adoption, or succession. But do note that every practice is not a valid custom. Every practice is not a legally valid custom. For a custom to be legally valid, it must satisfy 7 conditions. These are: it must be ancient, it must be continuous, it must be certain and unambiguous, it must be reasonable, it must not be immoral, and it must not be opposed to the public policy, and it must not be against any express law. So customs and usage also play an important role in the development of Hindu law. That's all about ancient sources. So within ancient or traditional sources, we discuss Shrutis, Smritis, commentaries and digests, and finally customs and usages. Now let us move to the modern sources of Hindu law. The modern sources, as you see, are broadly divided into three categories, that is legislation, judicial precedents, and justice, equity, and good conscience. Now, after independence, many important parts of Hindu personal law were codified by Parliament in the year 1955 and 1956. The four major Hindu acts are the Hindu Marriage Act, the Hindu Succession Act, Hindu Minority and Guardianship Act, and Hindu Adoption and Maintenance Act. These four acts are very important for the study of Hindu law. We can say that in a way, these modern legislative enactments are reflections of Shrutis, Smritis, commentaries, digests, customs, and usages, things that we already studied so far. Parliamentarians, especially First Law Minister Dr. Baba Saheb Ambedkar, he must be given the due credit for bringing together the Indian society as far as personal laws are concerned by giving a codified form to Hindu law. The Hindu Marriage Act deals with marriage, divorce, judicial separation, restitution of conjugal rights, and other matrimonial remedies. The Hindu Succession Act, on the other hand, deals with inheritance and succession. The Hindu Minority and Guardianship Act deals with guardianship of minor children, and the Hindu Adoption and Maintenance Act deals with adoption and maintenance. Today, legislation is an important source of Hindu law. Whenever there is clear statutory provision, courts will apply that statute first. However, a valid custom acts as an exception, allowing certain flexibility. You will come across proviso that are laid down in codified law in certain places. Do not worry about it now. You will get a clear picture when we study Section 5 of Hindu Marriage Act later. Just remember that it is important to know what a valid custom is, as it is required later when we study Section 5 of Hindu Marriage Act, where we will come across exceptions which will say that you cannot do certain thing unless valid custom permits to do so. I am deliberately refraining myself from elaborating here because I don't want to confuse you at this moment when you are not clear about Hindu Marriage Act itself. Now, the second modern source, that is judicial decision, also called as judicial precedents. So under judicial precedent, the court interprets Hindu law and applies it to the real life dispute. When higher courts decide a legal issue, that decision becomes a precedent for lower court. It is based on the doctrine of stare decisis. The stare decisis means that court should follow previous decisions when the same legal issue comes again. In India, Article 141 of the Constitution is very important in this context. Article 141 says that the law declared by the Supreme Court shall be binding on all the courts within the territory of India. So the judgment of the Supreme Court is binding on all the courts in India, all the courts of all the high courts as well as the subordinate courts. Similarly, judgments of a high court are binding on all subordinate courts. See, you need to understand that judicial decisions are important because no matter how good a legislation you make, you cannot cover every possible situation. कल कौन सा नया सवाल कोर्ट के सामने आ जाए आप बता नहीं सकते. Court's job is to interpret the law, remove doubts, and fill gaps whenever and wherever they appear. Now, the third and last modern source is justice, equity, and good conscience. This source becomes important when there is no clear rule in ancient Hindu law, no valid custom, and no specific statutory provision laid out in law. In such cases, court decide the matter according to the general principles of fairness, justice, and equity. In simple words, the court asks what would be fair, what would be reasonable, what would be just in this situation. That is the idea behind justice, equity, and good conscience. So this source is used when the law is silent on certain matter or it is ambiguous or incomplete. Now let us quickly revise. The sources of Hindu law are divided into two broad categories, that is ancient and modern. The ancient is further divided into categories like Shrutis, Smritis, commentaries, digests, customs, and usages. And the modern source include legislation, judicial precedents, and justice, equity, and good conscience. Shrutis mean what is heard, and Smritis means what is remembered. Commentaries and digests help in interpreting Smritis, Customs are ancient, continuous, long-standing practices which are not immoral and not against public policy and having the force of law. Among the modern sources, legislation is the most important one. Judicial decision help in interpretation and explanation of law, and justice, equity, and good conscience helps court decide cases where no specific law is available. So friends, this was an explanation of sources of Hindu law. In the next video, we will separately study the two important schools of Hindu law, that is Mitakshara school and Dayabhaga school, and we will also compare both of them in a simple way.